In this video, we will try to understand what is the good character requirement for the British citizenship. So recently on 13th February 2025, Home Office updated some guidance. So we will discuss that in this video. And we will also discuss the penalty, the fines. For example, you get 3 points on your license and £100 fine. Are you allowed to get the British citizenship on the basis of that? So we will discuss that in this section. So this is the section for fines, and if we go down, then we have fixed penalty notice, penalty charge notice. Penalty notice is for disorder. We will discuss this in this video. So without wasting time, let's start. But first, let's try to understand what is the good character requirement for British citizenship. The good character requirement is a statutory condition that must be met for an individual to be granted British citizenship, set out in Schedule 1 to the British Nationality Act BNA 1981. Good character is not defined in the statute, but relevant factors to be considered are set out in Home Office guidance. This includes consideration of immigration history, criminality, and other behaviors deemed relevant. Now let's discuss what changes did the Home Office make to its good character guidance. On 11th February 2025, the Home Office updated its good character guidance to state that anyone has entered the UK illegally is presumed not to be a good character and will generally be refused British citizenship. This includes individuals who later obtained leave to remain or indefinite leave to remain. Next question is, does the new guidance affect refugee and victims of trafficking? Yes, the updated guidance can adversely affect refugee, asylum seekers, and victims of trafficking or modern slavery, including those who entered the UK illegally. These individuals may now be refused British citizenship even after being granted protection or leave to remain. Next question is, can a person still be granted citizenship if they entered the UK illegally? In principle, yes. The guidance acknowledges that each application must be considered on its merits. However, it is also stated that discretion to grant citizenship in such cases should rarely be exercised. Therefore, applications involving previous unlawful entry or stay are likely to be refused unless exceptional circumstances exist. Next question is, can the Home Office refuse citizenship to someone who has indefinite leave to remain? Yes, indefinite leave to remain does not guarantee that a person will meet the good character requirement for naturalization. The updated guidance confirmed that individuals may be refused citizenship even if they currently hold lawful status, including ILR. Now let's go back to the good character requirement which is provided by the Home Office, the guidance. In the guidance, we will click on the left side, pending charges and prosecutions. A person may be subject of investigation by law enforcement before they are charged with an offense, or they may have already been charged and are waiting to go to court. Pending charges and prosecutions may be discovered through criminality check because they are self-declared by the person or through information passed to the Home Office. Citizenship will not normally be granted to a person who has a pending charge or prosecutions. The next section is failure to disclose convictions or criminal proceedings, where an applicant has attempted to conceal criminal charges or has failed to take responsible steps to notify the Home Office that they have a pending charge or prosecutions. You must follow the guidance on deception and dishonesty. However, you must be aware that a person may not know there is an investigation into their behavior or criminality. Now let's discuss the council tax. Non-payment of council tax. An application will not normally be refused where the person has been unable to pay council tax because their financial position, particularly if an arrangement is being or has been negotiated with the relevant authority. However, Payment of the council tax is a legal requirement and non-compliance is a punishable offense. Therefore, an application will normally be refused where a person has either unreasonably failed to pay, provided false statement or false evidence, including failing to declare their circumstances to avoid paying the correct rate. Now let's discuss the last part, which is fixed penalty notices, penalty charge notices, and penalty notice for disorder. In this section, they have provided all these charges. I'm not discussing all of them, but I'll put the link of this in the description. The guidance says fixed penalty notices, penalty charge notices, and penalty notices for disorder are imposed by the police or other authorities enforcement officers for traffic rule violations, environmental and civil violations. A fixed penalty notice may also be issued where a person has committed an offense under the coronavirus regulations. It is a way of criminal justice system disposing of minor offenses without the need of person to attend court. Receiving one does not form part of a person's criminal record. A fixed penalty notice will not normally result in refusal unless the person has failed to pay or has unsuccessfully challenged the notice and there were subsequent criminal proceedings resulting in a conviction. In such instances, they should be treated in line with the sentence imposed by the court. However, multiple fixed penalty notices over a short period of time could demonstrate a disregard for the law and therefore demonstrate that someone is not a good character. So if you getting a fixed penalty point, for example 3 points on your license and you have received £100 fine, but if you keep getting again and again, that means you may not be granted British citizenship. Make sure you follow the rules and look after this guidance.